This is a part 2 video of on Memorandum of Association in Companies Act. In the last session we have seen about the name clause and the registered office clause. Memorandum of Association is an important document in the company which is filed at the time of incorporation, because it gives the important details about the company. It gives the name of the company, it gives the address, and it gives what are the activities the company is going to take. It gives the information about the capital and about the liability of the shareholders. Among all things, the object clause is a very important thing, because this is the activity the company is going to take. By seeing the activity, others will assess the risk involved in investing in the company. For example, if there is a company, if there are two companies, one company is dealing with film production, another company is dealing with jewelry business, the investor may invest in the shares of the jewelry business because the risk is limited compared to the film producing company. In jewelry, gold will be there, no value reduction in value because of time. If the goods are not sold, gold will be in the shop, risk is less. But in the case of film producing company, sometimes they may get enormous profit, sometimes even the project will not be completed, some issue may come. The risk involved is more. A person who wants to take more risk will go to the company which is producing film. Who want to play safe will go to the company which deal with the jewelry business. So it gives a notice to the other people. It helps the shareholders, it helps the creditors, financial peoples, that is banks and financial institutions, to assess the risk involved in investing the money in the company or in giving loan to the company. This is object clause. There is another condition, a doctrine called Vires. The company should not go beyond the objects in the Memorandum of Association. Vires doctrine, it is called Doctrine of Vires. Vires means beyond the power. You should not go beyond the power given to the company. The company is for taking these activities. You should not do anything beyond that. Why this doctrine is there? Take the same example. There is a company, jewelry business company. This person has invested money, the shareholder. Bankers have lent money to the jewelry business company. Having so much money that people wanted to go for film production. If they are going for film production, if there is it is a risky business, there may be a loss. If there is a loss, film production will be over and this gold business will also go risk. Because at the time of investing money, the shareholders were thinking that the company is going to do only the jewelry business, so they invested. And if the people are investing in some other risky activity and resulting in a loss to the company, then the shareholders will be affected. To safeguard the interest of the shareholders and the creditors and others, the rule has come. It is there for more than 1.5 century, 150 years. This rule is any activity which is beyond the power of the company, which is not any activity which is not in the object clause, the company should not take. If anything is done, it is Vires, the contract is invalid, void ab initio. From the beginning it is not valid, it is void. You cannot ratify, even the shareholders cannot ratify it. This is the doctrine of Vires. Doctrine of Vires means the activity is taken which is not in the object clause. Any transaction done in connection with that activity is void ab initio. It is void from the beginning. It cannot be ratified, even estoppel, delay, anything cannot give life to that contract. For example, there is a company running a omnibus. That Memorandum of Association gives the object clause as running omnibuses. The company people thought that running taxis are profitable and they invested money on taxis. 150 taxis purchased. They called the shareholders. They told that this is a position. Shareholders were also willing to say they were willing to take the new activity. It is also a very good business we will do. They wanted to ratify that contract. It is not possible. It is void ab initio. Ratifying a contract which is not valid, a contract which was void on that day itself is not possible. What they have to do is they have to first change the object clause, then they have to go for the contract. This is the ultra-vires, ultra-vires. Doctrine of ultra-vires, which says any activity, any transaction done in connection with the activities which is not in the object clause is void ab initio, cannot be ratified. This is the rule, but in England, Companies Act 2006, they have removed the object clause from Memorandum of Association to Article of Association. There the contract, this doctrine is not there, that rule is diluted. Doctrine of ultra-vires is not there. But in India it is continuing because they have the investment culture, that English people. And in our country, to protect the shareholders and the other people, we continue with the doctrine of ultra-vires. Don't take any activity which is not in the object clause. Now we will see the case laws. The original was case law, a famous leading case law on this is Ashbury Railway Carriage and Iron Company Limited versus Ritchie. Ashbury Railway Carriage and Iron Company Limited versus Ritchie. This is commonly called as Ashbury Railway case. The object clause says sell or lend railway wagon or carriages or all kinds of railway plans. They can sell or lend railway wagons or railway carriages and all types of railway plans. They can carry on business of mechanical engineers and general contractors. This is the object clause. But what they have done is they have financed laying of railway tracks at Belgium. Subsequently, they noticed that this is a ultra-vires contract. It went to the court. The company was, the other person was contesting the case. His defense was, there is a word general contractors, so you can take it as a general contractors and make it as a valid contract. But the court held their main activity is hiring, sell or lend and hire railway wagons. Financing is a different activity, so the activity is ultra-vires the object, it is not valid, it is a void contract. There is an Indian case, A. Lakshmanaswamy Modaliyar versus LIC. Object clause says that you can give money for charity. They gave money charity, but when it went to the court, it was held that the charity should be for the benefit of the business of the company, otherwise it is not valid. So, the company cannot take any activity which is beyond any activity which is not in the object clause. What the companies are doing? Companies are now doing a long list of activities. When they incorporate itself, they make everything in the object clause. For example, the same thing. If it is a omnibus company, they will write omnibus company. They will say running of minibuses, running of autos, all type of things. They first itself they make it in the object clause. But the courts are taking only the main thing as object clause and they don't take the other thing as a object clause. Now we will see what are the consequences of a contract which is ultra-vires. If somebody is entering into ultra-vires contract, what are the consequences? One thing, number one, the shareholders can go to the court and restrain the person from entering into a contract. He can get an injunction. For example, the same example you will take. Jewelry business, this person has invested shares. The jewelry business person is going for film production. Then this person will go to the court, get an order restraining the company from entering into the film field for film production. Number 1, injunction. Shareholders or creditors, anybody can get an injunction. Number 2, personal liability of the directors. The directors will be personally liable. If they are taking anything which is not in the object clause, the persons will be liable. In Bombay High Court, in Jahangir or Modi versus Shamshi Ladha, in this case they held that the directors will be compelled to restore the company money. They don't have the right to take the company money for an activity which is not in the object clause. So they have to restore the company money. There is another one. If they are doing, third one is they are doing something which is not in the object clause, they are working beyond their authority. It is a breach of authority. Company, who is running the company? The managing director, directors, they are because all the persons cannot manage the company. These people are giving authority to the managing director, directors to do some business which is listed in the object clause. If they are doing some business which is not listed in the object clause, then that means that people are doing something which is not in their authority. It is a breach of authority. There is a case, Weeks versus Propert. In this case, they have already exhausted the borrowing powers. The shareholders gave something as a borrowing power, you borrow up to this money and do this business. But they exceeded that borrowed money, then the directors were held liable, personally held liable. But if there is a activity which is ultra vires, the company has taken something, some property, then the courts will allow them to take back. In one Madras High Court case, Ahmad Seth versus Bank of Mysore. In this case, the company has taken on mortgage a property. It was not in the object clause. Since company money has paid by the company, the court allowed to take back the money. And now another situation may come. There may be a liability because of negligence in conducting the activity which is not in the object clause. One example, same example, it is an omnibus company, a company which has an object clause only running omnibus. This person, as these directors, have purchased taxis also. Accident occurred because of the negligence of the driver. The driver, in the normal course, if it is a negligence of the omnibus driver, company will be liable because the company is liable for the activities of the agent. In this case, the taxi driver is not the agent of the company because the activity is not the company's activity. Company's activity is only omnibus activity. Only the directors have purchased the taxis which is not in the object clause. There, because of the negligence, accident occurred, somebody to be paid, compensation to be paid to somebody. If that is a case, that persons will be personally liable. Company will not be liable for anything happened due to the negligence of the persons in the course of doing some business which is not in the object clause. Now we will see the alteration of objective. The company can alter the objects. Section 13 subsection 8 deals with this. A company can alter the objects. They have to pass a special resolution. The intention should be intimated to all by way of paper publication. 2 paper publications where the registered office is situated. One is in English, one is in a local language. The shareholders should be given an option to exit. The rules of the SEBI stock exchange should be complied with. But if the company is having funds received from the shareholders, excess funds, the company cannot change the object clause. Take the same old example. Yeah, jewelry business company, limited company doing jewelry business, received so much money, wanted to produce films and they want to alter the object clause and then go for the film production. That is not possible, because once you are having the excess money, unspent amount received from the shareholders, you cannot change the object. Otherwise, you can change the object by passing a special resolution, paper publication, give an option to the shareholder to exit from the company, and then file with the registrar. Registrar will give within 30 days approval for that, and new object will be added to that. Within 30 days he will give. No outside approval is required. Only thing is that paper publication. Now we will see the liability clause. The liability may be limited or unlimited. It should be mentioned in the liability clause. Unlimited liability means to any amount they are liable. Unlimited means limited to the extent of the face value of the share. If a person is taking 100 rupees a share, his liability is to the extent of 100 rupees. If he has paid fully at the time of purchase itself, then he has no liability after that. If the person has paid only 50 rupees at the time of purchase and 50 is unpaid, his liability is 50. Whenever the company asks for it, he has to pay, limited to the extent of the face value of the shares taken. In the case of liability limited by guarantee, the person can move away from the company, but he will continue to be liable up to 1 year for the debts, for the expenses contracted till the date of his exit from the company. He can go out, but up to 1 year his liability will be there for any expenses or any liability. Before this date, he has to pay for it. This is a liability clause. Then capital clause. In capital clause, your company has to mention what is the total capital. That will be divided into this much face value shares, number of shares, and the face value of shares. In the case of one-man company, that person has to declare who will be the next man in case of his death, who will take care of the shares and the company. Last is the subscription clause. There they will declare that we are forming this company and we will take the number of shares mentioned against our name, and thereafter below that they will be signing. This is regarding Memorandum of Association and the Doctrine of Ultra Vires. In the next session we will see some other topic.